A plea to 2 counts of felony battery, be placed on probation for 5 years on each count, consecutive one to the other. There will be a sex offender probation, but not as designated. Fines and court costs as appropriate.
I don't understand that.
Your Honor, we're asking for sex offender probation conditions, but he does not require designation. So there'll be some restrictions on where he lives. This does not require a GPS, Your Honor, based on the charges. And there are no restrictions on the internet, but the rest of the conditions would then apply.
Okay. That's all very vague in this plea agreement. It seems to me that we need to make sure and detail that, because this is what he's agreeing to. You understand my point? I don't know what it means. How will a probation officer know? Does he need GPS? Is there restriction on the internet? What are the restrictions? I just want to be clear. That's what we're doing. When we're plea, you want to be clear, and of course the state wants to be clear, but the defendant really wants to be clear because you don't want to be violated on something. No, I didn't realize that. That's
right. Yes, sir.
Your Honor, for the record, sex offender probation is governed by 948.30, so those conditions would apply with the exception of the GPS and any restrictions on internet access.
Okay. Put that in there. It says sex offender, but it actually doesn't say sex offender probation requirements in there. Here you go. This is the.
Yes, ma'am. I'll make that clear for the record. We're filing an amended information, Your Honor. It reflects a 2-count information, and in association with that, it's amending a originally 4-count information. So the state will announce in all possible counts 3 and 4 on the original information.
Very good. So this is a revised count 1 and 2.
Yes, sir. And this is also an agreement with the victims.
And it is a downward departure as well, correct?
It is a downward departure, Your Honor, and it's based on an agreed upon uncoerced plea agreement. And we do believe, Your Honor, based on the totality of the circumstances and the evidence that's available, and discussions with the victims, that this is an appropriate resolution of this case for the record.
One thing, I'm going to state just to review it, make sure, because that's all right. I don't mean to be precise, but it's very important for your client as well as everybody else to be precise on this.
Yes, sir.
Do you want me to, I'll initial it real quick. Make sure. There we go.
Thank you. Okay. So, and the defense is in agreement with regards to the score sheet?
Yes, sir.
Okay. Very good. Mr. Everett, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of the plea, and there was some discussion. I want to be precise about what the plea agreement is. There's a revised information that would basically have 2 counts of felony battery, correct?
That is my understanding.
And on both of those, you're going to be adjudicated guilty and have 5 years probation, the specific, with basically sex offender probation. It's not designated as such, but it's the supervision pursuant to 948.30. So those same provisions of the plea agreement are contained in your written plea agreement that you've signed, correct?
Yes, sir.
And have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney, make sure you understand all the legal ramifications of this plea agreement?
Yes, sir.
Are so the probation is essentially a 10-year probation because it's 5 years consecutive. It's stacked on top of one another. Do you understand that?
Yes, sir.
Okay. And you understand that as contained in the plea agreement, I'm sure through your discussions with your attorney, you understand that this is a final resolution of this case, and that you're waiving a number of valuable rights. As a matter of fact, we were teed up to go to trial. You have a right to go to trial. You're waiving that right, as well as a number of other related rights related to the trial to make the state prove their case beyond a reasonable doubt, confront witnesses. Those are all rights that you have under the U.S. Constitution that you're waiving in order to enter into this plea agreement. Just want to make sure you're clear about that and that you're in agreement with that.
Yes, sir.
Okay. And is there a stipulated factual basis for this plea?
We do so stipulate, Your Honor.
Okay. Very good. You don't have any other questions regarding this plea agreement with your attorney?
No, all my questions I discussed with him, and he also discussed with the prosecution.
And you believe that this plea agreement is in your best interest?
I do, Your Honor.
Nobody promised you anything other than what's contained in here? Nobody threatened you or coerced you to get you to enter into this plea?
No, there is no provision.
Okay, very good. Based upon that, the court will accept this plea agreement with the revised information. There'll be an adjudication of guilt on the 2 felony battery charges, and the defendant will be sentenced to 5 years probation consecutive to each other on both counts, and there'll be supervision pursuant to Florida Statute 948.30. There is no GPS requirement, no restriction on the internet contained in here, and no unsupervised is the no unsupervised contact with the minors, does that mean that provision is not a part of it? Or does that mean there will be no
Unsupervised contact with minors.
Okay. Very good. Okay. Any questions? Anything else?
There you are.
No, I'm not familiar. Are there initial reporting instructions for probation?
Yeah, reporting immediately after this hearing.
You do things a little bit differently.
No, that's all right. No, that's a good question. And we, again, do you want to make sure everybody's clear?
Yes, sir.
It's never bad to ask a question.
Yes, sir.
I mean, we're all trying to, I ask questions. You know, obviously I wasn't clear about language. Sometimes people can look at a provision and see different things. That's one thing I learned early on as a lawyer, and that's, we don't want that to happen in this case.
Very good. Well, that's all I have for the court. For all the excuses.
Your excuse. Thank you. Have a good day.
Mr. Couch, if your client is just checking with probation, we've already talked a little bit about it, so if there are questions.
Okay. Now,
Who's next? Your Honor, I believe Mr. LaPella might be ready.
we ready? I can go in any order. We've got a couple of plea agreements that we were done. We can get those done, or?
This is also a plea agreement, Your Honor.
It's a plea agreement?
I apologize in advance. I do not have a score sheet, but I will provide it to the court.
Okay. Mr. LaPella?
Permission to approach, Judge.
You may. Thank you. Would the defense please announce the plea?
Thank you, Your Honor. Sean LaPella and David Roy for John Champlain on 21 CF 696. This case was scheduled for trial. However, in Illinois, we've reached an agreement with the state in which Mr. Champlain would be withdrawn as previously in a plea of not guilty and in a plea of no contest to the lesser included offenses on counts 1 and 2, legal lascivious conduct. Those are second-degree felonies. He'd be adjudicated guilty of those 2 charges and be sentenced to 15 years probation, each count concurrent. All standard conditions. In addition, he'd have to complete sex offender. He'd have to complete sex offender counseling, apply with sex offender designation, comply, and the statutory requirements of Florida statute. He's also subject to electronic monitoring is required by statute, and we ask that it be set at $1 a day. Mr. Champlain is indigent, he's not employed, and has suffered a lot of financial hardship, specifically due to these charges. Like I said, sexual evaluation and treatment is required, no contact with the victims, KHF and KRF, or their immediate caregivers, also no unsupervised contact with any minors. Court costs are set at $817. We checked with the clerk, we believe that's the correct number. Defendant may request early termination of supervision after 120 months or 10 years if all conditions are met and he has got no violations. Also, as a condition of probation, he's to have no alcohol. And we're requesting that the court waive the cost of supervision based on his status of not being employed and the fact that he's subject to these costs and fees for the monitor. And I believe that comprises the agreement.
Your Honor, that is the state's agreement. We would announce for the record it was originally a 3-count information, so we announced a no cost of count 3 in return for the plea. And Your Honor, also for the record, we have met with the victims, discussed this at length, and they are in agreement with this plea.
Do we have a statutory provision for the amended information?
Statutory provision.
What statute is it under? I'm doing that for the benefit of the
To
court.
see which subsection. I know it's 800.
The lesser included, it's not an amended information.
Oh, it's not amended information?
No, Your Honor, it's not. It's
Okay.
a lesser included. It's still the 800.04
Okay,
series.
perfect. Okay, I just want to make sure we were clear on that. They had all their information. And the score sheet that's going to be provided, is it a downward departure?
Yes, Your Honor, it is a downward departure, and we would agree that it's based on uncoerced plea. And again, we have discussed it with the victims, totality of the circumstances, and they are in agreement with us.
Defense would stipulate.
Very good. Mr. Champlain, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I did.
Okay, slide over there so you can talk into that mic. So, Mr. Champlain, you heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in the written plea and sentencing agreement that you have signed. My first question is, have you read this plea and sentencing agreement closely?
Yes, I have, Your Honor.
And have you gone over it in detail with your attorneys to understand all the terms and conditions of this agreement?
Yes, I have, Your Honor.
Okay. And you understand that by entering, importantly, among other things, this plea agreement talks about the waiver of certain rights. You're getting ready to go to trial. You're waiving, that's a right. That's an absolute right. You have a right to go to trial and tell the state that they have to prove their case. Okay? You're waiving that right in order to enter into this plea agreement. You understand that?
Yes.
There's some other legal rights that you're waiving as well. Have you gone over all those with your attorney, make sure you understand that and you're entering into this freely and voluntarily?
Yes.
Okay. And you understand that by entering this, importantly, this will be a final resolution of this matter?
Yes.
You understand that? Other than the probation you're going to be on. And does the defense stipulate that there's a factual basis for the entry of this plea?
Yes, Your Honor.
Defense would stipulate.
Very good.
Your Honor, absent the score sheet, I do have the numbers for the court, for
Okay.
the record. Your Honor, they are 2 second-degree felonies, so it would reflect a maximum of 30 months, or I'm sorry, 30 years DOC. The minimum guideline would be 20.1 months DOC based on a total of 54.8 months.
So, final question, Mr. Champlain, have you entered into this freely and voluntarily?
Yes, sir.
Nobody promised you anything other than what's contained in this agreement, or nobody threatened or coerced you with anything to enter into this plea?
No.
You're doing it freely and voluntarily?
Yes.
Okay, very good. Based upon that testimony here today, the court will accept the plea agreement, and as to counts 1 and 2 on the lesser included offenses of lewd and lascivious conduct, the defendant will be adjudicated guilty and will be sentenced to 15 years probation on each count. They will be served concurrent. They'll have all standard conditions. There will be a sex offender designation. You must comply with all statutory requirements of Florida Statute 943.0435. You've gone over that with your attorney?
Yes.
Okay. The electronic monitoring as required by statute, and it will be ordered at $1 a day. Sex offender evaluation and treatment as required by statute. No contact with the victims KHF and KRF. And that's no contact. Even if they try and reach out to you, and your obligation to stay away from them. If they walk up to you out on the street corner or at Walmart somewhere, you've got to walk away from them. That's your obligation. Do you understand that? That's a very strict obligation in this agreement. You understand that?
Yes, I do.
Okay. And in addition, you'll have no unsupervised contact with any minors. Court cost of $815. The defendant may request early termination after 120 months, after 10 years, if all the conditions are met and there's no violations. Also, as a condition of this probation, there'll be no alcohol while on probation. You understand that?
Yes, Your Honor.
Okay. And the court will waive the cost of supervision. Anything further from either side?
If the court was interested, I think the statute that the lessers are is 800.046B is in Bravo.
Very good. Very good. Thank you. So if you'll, as soon as after you get fingerprinted, you have to immediately check in with probation. Okay?
Yes. Thank you, Judge. That's all we have.
Thank you. Mr. Noakes, you ready?
I'm ready, Judge. We got an inmate, Martavius Story.
Okay.
Thanks, we're ready for Martavius Story.
You may.
Judge, on behalf of Mr. Martavius, Story, 22 CF 281. Judge, the state had filed an amended information and alleged 4 counts. Today, based upon plea negotiations, we've agreed to plead to count 4, which is a misdemeanor, and he would be sentenced to credit for time served, pay court cost of $275, and a court-appointed legal assistance fee of $150. And I believe the state has an announcement as to count 1, 2, and 3.
The state would announce an all crossing counts 1 through 3.
Okay. And the 4th count that he's pleading to is resisting arrest without violence, correct?
That's correct.
That's correct, Your Honor.
Okay. Very good. Mr. Sawyer, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. You heard your attorney state the terms. You can put your hand down. You heard the term. Your attorney state the terms of your plea agreement, correct? And I see that those same terms are contained on your written plea and sentencing agreement that you've signed.
Yes, sir.
So my first question is, have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney? Make sure you understand all the legal ramifications.
Yes, sir.
And you understand that by entering into this plea here today, you're waiving the right to go to trial.
Yes, sir.
Certainly understand why. Seems like a pretty a generous plea agreement. You'll be, 3 of the counts have been dismissed. The 4th count of resisting arrest without violence. You'll be entering a no contest plea. There'll be an adjudication of guilt. You'll get credit for time served. So basically you'll be able to get out and no probation to follow. Is that your understanding what the terms of the agreement are?
Yes, sir.
Okay. And you believe it's in your best interest to enter into this plea today?
Yes, sir.
And you understand this is the final resolution of your case? Very good. Based upon that testimony, the court will accept the plea agreement, and the state's dismissal of counts 1 through 3 will adjudicate the defendant guilty on the single resisting arrest without violence, and the defendant will be, as I said, adjudicated guilty and sentenced to credit for time served. And what are the fees? The court costs are $275 and a $150 fee. How long does he have to pay that?
We didn't have an agreement as to that, Judge.
You want to put that down and just leave it blank? I mean,
How long will it take you to pay that money?
well, very good. Okay. State okay with that? 30 days.
30 days is fine, Your Honor.
Okay. Thank you, sir.
Judge, and just so the record's clear, and I know I wrote credit for time served, but it's time served, so basically he's done all the time he's supposed to do on this case.
Right.
Okay, very good. Thank you, Judge.
Thank you. Mr. Harper, you want to?
Yes, Judge. I have two. Both are in custody, ready for Paul Griner and Darius Wilson. Griner, the liquor. Just one moment, Judge. Judge, Rudy Harper, on behalf of Paul Griner, before the court on 21 CF 2041, 22 CF 1349, 22 CF 1980, and 22 CF 2273. Judge, I've spoken with the state. I think there are some issues with respect to witness availability for a potential trial this cycle. I've spoken with Mr. Griner, and I think that he's asking the court, or the state rather, to consider a treatment program that would hopefully be incorporated into a resolution of this. What I'm asking the court to do, and I think the state is okay with moving it, is if we could set this on May the 9th on the miscellaneous court date, just for purposes of status, to find out where we are with respect to this inpatient treatment program that my client is inquiring about. I would ask to continue that for that purpose.
The state has no objection, Your Honor, and I believe both parties agree that if that treatment program is not an option and does not resolve the case, then we'd be ready for trial that cycle.
So the state is at least open to this treatment plan being a resolution. I don't want to just, if the defense is saying, and you're like, we ain't agreeing to any of that.
Your Honor, if it's an inpatient, and that's what we want to be clear about, if it's an inpatient, then we're open to that based on Mr. Griner's history and some of the issues that he's faced. We're willing to at least look at that, but we have conveyed to Mr. Harper it does need to be inpatient.
And to be fair, Judge, I do need to provide the substance and nature of that type of program and get her approval before anything's signed off on. So
Sure. Well, yes.
Yes,
But
sir.
I didn't want to do it
If it wasn't even an option.
if it wasn't,
a possibility.
yeah, if this wasn't real. You know,
Yes, sir.
unfortunately, on one side or the other, may want to do something. The state, has their position, the defense has, if one side wants something, the other side's like, no way, Jose, then we go to trial.
Yes, sir.
But if you have the potential, because a plea is not something I'm involved in, it's strictly whether the state believes that the plea agreement is fair and the defendant does as well.
I need to just get some parameters that's Ms. Basso's fine with, and then we can move on from there, Judge.
Mr. Harper's been very good about communicating with the state on behalf of his client.
Okay. So we'll come back on May 9th in the morning. And we will, I'm assuming, I'm going to put it down, I'm making a statement. This is, we were, gearing it up for a trial.
I understand.
So this is a last.
This is the last.
A real last. No, but this is the last. I mean,
Sure.
I just want everybody to understand that
We need closure, Judge.
we need closure. So if we can't come to agreement, and I'm not trying to push anybody to come to agreement, but if you can't come to agreement, you have a right to go to trial
state has the right to pursue the trial, and court will cooperate with both of you in that regard.
Understood, sir.
Okay, thank you.
Thank you, Judge.
Next one I have, Judge, is Darius Wilson.
Did I? I'm sorry. I noticed for me to sign.
Judge, I'm going to provide the courts with a copy of the front page, just because it's kind of a convoluted plea, just so the court can track along when I announce.
That'd be great. Thank you. Thank you. Would the defense announce the plea?
Yes, Judge. Rudy Harper on behalf of Darius Wilson. He's before the court on 22 CF 189, 21 CF 2700, 21 CF 1350, 20 CF 2791, 20 CF 999, and 20 CF 998. Judge, in 21 CF 1350, this will be a plea to count 1. The state is going to no pros counts 2 and 3. It will be as charges to the remaining counts and charges. In 22 CF 189, 21 CF 2700, and 21 CF 1350 count 1, will be adjudicated guilty. It will be placed on 12 months of community control. That will be followed by 48 months of probation. This will be concurrent between only these counts and charges. 4 years Department of Corrections, which will be suspended, again concurrent between only these counts and charges. In 20 CF 2791, 20 CF 999, and 20 CF 998, to be adjudicated guilty, placed on 5 years of probation. That will be concurrent between only these counts and charges, but consecutive to the 3 previously listed counts and charges for a combined total of 10 years of supervision. He'll be sentenced to 4 years Department of Corrections suspended, again concurrent between only these counts and charges, but consecutive to the 3 previously listed counts and charges for a combined total of 8 years Department of Corrections suspended. While on supervision, he needs to attend and complete a 90-day substance abuse treatment program at Recovery Bay Center, located at 9721 Thomas Drive, Panama City Beach,
And
Florida.
let me just break in on that. I would assume that he's already been accepted into the treatment.
Yes, sir, he has.
Okay, go ahead.
As a condition of supervision, he'll consume no drugs or alcohol during supervision, no medical marijuana card permitted during supervision, be assessed all applicable court costs and fees. There is a GPS monitor requirement during his supervision. We're asking that be at the lowest permissible daily rate, and probation may terminate at the 2/3 mark if all requirements are complete and there are no violations.
And that termination at the 2/3 mark would be for all of these?
Yes, sir.
Yes, sir. If I may approach, Judge?
No.
And Your Honor, that is the state's agreement, and for the record, in case number 21-1350, we are announcing all costs in counts 2 and 3.
Very good. And is the defense in agreement with the score sheet?
Yes, Judge. I believe that it's downward departure is a part of the negotiated plea agreement, Judge.
It is, Your Honor.
Okay, Mr. Wilson, I need to ask you a few questions. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir. I see that.
Mr. Wilson, you just heard your attorney state the terms of your plea agreement in detail. And I see that those same terms are contained on the written plea and sentencing agreement that I kind of tracked as he was announcing the plea agreement. My first question to you is, have you read this plea and sentencing agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney to make sure you understand all the legal ramifications? Even as he prefaced this, this is a little bit of a complicated agreement, a lot of ins and outs. And there are some other things in the plea agreement itself that are important, mainly which, you're waiving the right to go to a trial. You have a right to go to a trial, make the state prove their case beyond a reasonable doubt. You're waiving those basic constitutional rights by entering into this plea agreement. You understand that? And have you gone over that with your attorney in detail?
Yes, sir.
You believe this is in your best interest to enter into this?
Yes, sir.
Is there a legal basis,
Yes, sir.
factual basis for the entry of this plea? And nobody promised you anything or threatened you to get you to enter into this plea?
No, sir.
Okay. And you believe it's in your best interest to enter into this?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea, and the court will, I'm going to go through the core of this, some of the details that will be contained in this, but I want to make sure that we put it on the record that on 21 CF 1350, you're pleading to count 1, and state's going to null pros counts 2 and 3 as charged. And as to the sentence, there'll be an adjudication of guilt, actually on all the remaining charges. In 22 CF 189, 21 CF 2700, and 21 CF 1350, count 1 only. In addition to the adjudication of guilt, there'll be 12 months community control followed by 48 months probation. There will be, all those counts will be served concurrently. In other words, they're served at the same time. You'll also have on all those counts individually 4 years Department of Corrections suspended, again, concurrent within those charges. Okay, so those will just total of 5 years probation, 4 years suspended sentence on those charges only. On the other charges, 20 CF 2791, 20 CF 999, 20 CF 998, again, adjudication of guilt on all these, 5 years probation, again, concur on each of those charges, but they're concurrent on those charges, but they're consecutive to the previously identified charges. So you got 5 years probation, followed by an additional 5 years probation. Actually, 1 year community control and 4 years of probation, but that's 5. And then additional 5 consecutive. So they're stacking those. Those are on top of one another. But within those 3, they're concurrent. Okay? And in addition to these, you also have, again, 4 years of suspended sentence. But you're consecutive to the other 3, the 3 previously listed charges. So you got a total of 8 years DOC suspended. Okay? In addition, there's some other important issues in here. Attending complete substance abuse program is a condition, no drugs and alcohol during supervision, and the other things that are contained. The court will allow the cost of the GPS monitor to be at the lowest permissible daily rate, which is I think $1. And the probation may terminate at the 2/3 mark if all the requirements are complete and there's no violations. Okay? Check in immediately with probation when you get out, so you get that. I don't have to tell you this. You've gone through a lot of this and talked with your attorney and whatnot. You know, I know you're probably, as everybody is, happy to get out of jail. But this is the beginning. This ain't the end. It's the beginning of a lengthy road. So you're going to have to get up every day. It's got to be business one for you to get this. If not, you're going to be coming back. And these suspended sentences, they're real easy to turn into actual sentences. So if there's a violation, I promise you that's what the first thing the state's going to be asking the court to do. So you got to get up every morning and focus. Your probation officer needs to be your new best friend. And by that I mean you need to stay in real good contact with them, real good contact, so that you can navigate this. Okay? Thank you very much.
Thank you, Judge. That's all I have this morning.
Thank you.
We're ready for Mr. Brewster.
have a Brewster.
It might have been an add-on, Your Honor. I think it's on the docket.
I wasn't notified that it was added, I'm sorry, Your Honor.
Definitely.
Is it a plea?
Yes, Your Honor. We have Mr.
Just
Brewster
announce,
for a
just
plea
bring him out. Bring him out right
and
now.
Pitman for a plea. Yes, Your Honor.
Okay. Why don't you give me
Yes, Your
the name and the case number?
Yes, Your Honor. Robert Edgar Brewster, Brewster Jr., 23 CF 60. Your Honor, Mr. Brewster is approaching. This was a 2018 incident. Sadly, he informed me that his mother passed away yesterday. He's been in Alabama DOC custody for over 4 years. These charges are around that same time frame that led to his incarceration on that. May I approach with the agreement, Your Honor?
You may.
Does the state have the score sheet for Mr. Brewster? I'm sorry.
Your Honor, I have the score sheet printed out downstairs, if I can provide it to the court either later this morning.
I'm sorry?
The score sheet, I have it printed out downstairs, if I can provide it to the court.
I do have a 5, and it is.
Later this morning or this afternoon, at the hearings this afternoon. Your Honor, this is not a downward departure.
It is not a downward
It is
departure?
not a downward departure.
Okay. If you can just get it to me, I'll
Yes,
sign
sir.
it earlier. Thank you.
Your Honor, under the agreement, this third-degree felony grand theft charge, and there was also a contractor licensing registration charge, first-degree misdemeanor charge. They're going to be resolved with adjudication of guilt as charged. There will be 11 months, 29 days incarceration, and that's concurrent. I did not write concurrent. The court may want me to write the word concurrent prior to the word incarceration, or the court can let me do it on the record. So,
No, we'll put it in here.
thank you, Your Honor.
I'm sorry, say that again? I wasn't.
There's going to be 11 months, 29 days concurrent incarceration.
Okay. With each one of the charges.
Applicable
Gotcha.
to both of the charges concurrently. It's with credit for all time served and with credit for the state stipulating to credit for Alabama DOC time. I'm sorry, I don't think the state has signed the agreement, Judge. I may have skipped a step. I'm so sorry.
That's all
I
right.
don't think so, now that you mention it.
I don't think it has the signatures, Judge. I was confused.
That's all right. And I think you need to get the defendant to sign it, and you to sign it.
Yeah, I missed them all, Judge. I'm so sorry. I'm so excited to get it done. All right. We've been over it, though, Your Honor.
Okay.
Thank you. I got it. I'll do that.
Thank you.
I apologize, Judge. So there will be 11 months, 29 days concurrent incarceration between both counts with credit for all time served and with the state stipulating to credit for Alabama DOC time, and that this incarcerative obligation has been met. He has had over 4 years Alabama DOC. There would be applicable court costs. I think it's probably $515 in court costs. Madam Clerk may have more solid information. $150 public defender fees, and there would be, we're agreeing to a liquidated amount on restitution. It's $1,900 restitution to Mason Lee, and the outstanding monetary obligations will go to collections or lien within 6 months after release.
And those monetary obligations you're referring to, those are the fees and costs.
Fees and costs, and the restitution will go to lien if it is not paid within the 6-month period. That's
Okay.
That's a lien as to the victim.
Okay, very good. And I need you to do one thing. You've got them signed, but you didn't put concurrent.
Oh, Judge, I'm sorry. Thank you.
Mr. Brewster, it's important that when you enter into these deals like any other contract, which is essentially what this is, it's real precise so that you're clear and state that everybody's clear. We don't want any misunderstanding. Oh, I thought it was this and it was that, and we're back in court and you're trying to unravel it. So we're just trying to get it square.
Your Honor, I had sent back the version, but prior to our agreeing that the obligation had been met on the jail, so I'm writing that in as well.
Very good.
Is
the state in agreement as stated by Mr.
That's the state's
Medina?
agreement, Your Honor, and as Mr. Medina said, the state's stipulating to the 4 years credit because this offense occurred in 2018. In the interim, he has done 4 years in the Department of Corrections in the state of Alabama.
Mr. Brewster, I just need to ask you a couple questions. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay. So you heard your attorney state in detail the terms of your plea agreement, and I see those same terms are contained in your plea and sentencing agreement that you just signed, but am I correct in understanding you've gone over this plea agreement in detail with your attorney?
Yes, Your Honor.
You had all your legal questions answered about this plea agreement?
Yes, Your Honor.
And this is what you're agreeing to?
Yes.
You understand, importantly, as contained in the plea agreement, that you're waiving the right to go to a trial. This is really a final resolution because you're getting credit for time served, you're basically getting out. But it does impact you legally because there's an adjudication of guilt on both counts. So, I mean, it affects your record. I mean, I want to make sure you went over it with your attorney and you're entering into this freely and voluntarily.
Yes, Your Honor. He did a great job as well.
Okay. And did you hear that, Mr. Medina?
Yes,
We
sir.
don't, it's amazing, not that these are all difficult, how infrequently that happens, that people appreciate legal representation.
Thank you, Your Honor.
Even though a lot of people put in a lot of hard work, and it's, you know, these are tough on everybody.
And
you may not fully appreciate it.
Thank you, Your Honor, and I do appreciate Ms. Sharpless was speaking to the victim early this morning, so certainly the victim and the state deserve all the credit.
And the victim has been, as Mr. Medina said, has been consulted and is in agreement with this plea.
Your Honor, I do know that the victim has been talked about prior to this. I did leave a message with them this morning. And I asked them, I explained what was happening in court, and I told them to call me back if they had any questions. I do know that the restitution was the issue, so that's why I was comfortable doing this.
Okay. Thank you. Very good. Based upon the testimony of the defendant, the court will accept this plea agreement. There'll be an adjudication of guilt as charged, and the defendant will be sentenced to 11 months, 29 days incarceration on each count. They'll run concurrent at the same time. The defendant will get credit for all time served, and with states stipulating to credit for the Alabama DOC, which is essentially far in excess of what the 11 months, 29 days is. So basically mean your incarcerative obligation is completed here today. The court will do the standard court costs, restitution in the amount of $1,900 to Mason Lee, and all outstanding monetary obligations, including the fees and costs, and the restitution will go to collection or lien 6 months after release. Okay? Any questions?
No, sir.
Okay. Thank you, sir.
Thank you. Thank you.
My condolences.
This one's right here. Damon Pitman.
Damon O. Pitman is before the court in 23 CF 200. He's signing his, I'll date it for you. He's signing his plea and sentence agreement that the parties have worked out. May I approach the score sheet and the agreement, Your Honor?
You may. Thank you.
Your Honor, under this agreement, Mr. Pitman will be changing his not guilty plea to no contest, and there will be an adjudication of guilt. The adjudication of guilt was a very significant change. He had in his possession a common pocket knife when the incident occurred. He is currently charged with a burglary of a structure armed with a weapon, which is a life felony. The state has agreed, based on the clarification of the situation, to allow him to be adjudicated guilt to a lesser included offense, burglary of an unoccupied conveyance, third degree felony, level 4. That's on count 1, and the counts 2 and 3 were as charged, possession of controlled substance, third degree felonies. There will be a 24 months DOC suspended sentence. I did not write concurrent. That's supposed to be concurrent. Should I write that?
Yes.
I apologize, Judge.
It's all right. Come on.
Thank you.
Thank you.
Your Honor, in addition to the 24 months DOC suspended sentence, he has to do 6 months community control, and that's going to begin today. And so you'll need to report to 13 Kelly Avenue, Fort Walton Beach today to begin the community control. And the community control will be followed by 36 months of regular probation. There is a substance abuse evaluation requirement to be completed within 30 days, with any recommended treatment to commence within 60 days. He will have to do 100 hours community service, no contact with, letter of apology to, and $1,100 restitution to Randy Baker, and we agreed to liquidate that amount, so it will be $1,100 without need for a hearing. No trespassing at Holiday Inn Express, 127 Miracle Strip Parkway, Fort Walton Beach, Florida. Court costs, I believe the court costs are going to be $615 because it was a controlled substance case. $150 public defender fees, random urinalysis with a minimum of 1 time a month. That's the agreement, Your Honor.
State in agreement.
That is the state's agreement, Your Honor, and I did consult with the victim about the reduction in the charge. He did understand the reason for the reduction. He was supportive of the defendant being on probation so that he could get the restitution that was that he had to pay back. And this is not a downward departure, Your Honor.
Okay. Mr. Pitman, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state in detail your plea agreement.
Yes, sir.
And the same plea agreement is contained, I was tracking it as he was saying it, in your written plea and sentencing agreement, which I want to make sure you signed, which you signed. So my first question to you is, Did you read the plea and sentencing agreement closely? And did you go over it in detail with your attorney, make sure you had all your legal questions? A lot of ins and outs of this thing.
Yes, sir.
Okay. As a matter of fact, it's you need to understand this, because you got 6 months community control followed by 36 months regular probation. That's a few years.
Yes, sir.
You understand, you've been around the block enough, you understand how the system goes.
Yes, sir.
You get in here, they get a diversion program, sometimes you get probation, then you get community control. What's next?
Prison.
Prison. I don't want you to go to prison.
Yes, sir.
We got enough people in prison, okay? But you got to pay attention to this. I'm just being honest with you.
Yes, sir.
You got to jump through some hoops here.
Yes, sir.
You got to get up, you got to stay in touch, you got to follow the other requirements that are contained in here. You willing to do that?
Yes, sir.
Okay. So you understand that by entering this plea agreement here today, you're waiving the right to go to a trial and some other valuable legal rights. You believe that's in your best interest?
Yes, sir.
And this is the final resolution of your case. You understand that? Nobody threatened you to get you to enter into this? Nobody
No, sir.
promised you anything other than what's contained in here?
Yes.
In the plea agreement?
Yes, sir.
Okay. Very good. Based upon that, and did we go over the score sheet?
Your Honor, I know that he has less than 44. He's aware of that.
No minimum
44
jail sentence, and you're in agreement with that?
Yes, Your Honor.
Okay. So, Mr. Pitman, the court will accept your plea agreement, and the court's going to adjudicate you guilty on all 3 charges. The first charge, however, is a lesser included charge of burglary of an unoccupied conveyance. Obviously, very significantly different. You will receive 24 months DOC suspended sentence, followed by 6 months of community control, followed by, well, the suspended sentence is not followed by. It's a suspended sentence, and then you're going to have 6 months of community control followed by 36 months regular probation. So it's a total of 42 months, a little 3.5 years, okay, of probation. Got to do some substance abuse evaluation and follow recommended treatment, and within 60 days, community service. Then you've got, the no contact letter of apology to Randy Baker on this restitution, $1,100. Do you understand that?
Yes, sir.
No trespassing. No contact with Mr. Baker. Even if he walked up to you out in public, you got to stay away from him.
Yes, sir.
Your obligation. You're together, you're in trouble. He's not. Okay?
Yes, sir.
You willing to do all that?
Yes, sir.
Okay. Very good. And the other things that are contained in here. Okay? Any questions?
No, sir.
Your
Good
Honor,
luck.
the state just want to make sure that Mr. Pitman knows he needs to be ready to give probation an address because he's on community control. That is house arrest.
Yeah.
He is not free to leave his residence unless he has express permission or unless he's worked out a work schedule with probation. So they will be requesting an address from him upon his release from probation, and I'm assuming probation needs him to report today since it's
After he's
pre-lunch.
released
Yeah.
from jail. You said after he's released from probation. Okay. Do you have an address where you're going to be staying?
Yes, sir.
Okay.
But, Your Honor, he's indicating that you live in Crestview, but you do have to do your intake in 13 Kelly Avenue in Fort Walton Beach, and then they'll evaluate whether Crestview will be supervising or Fort Walton. Presumably it'll be Crestview, but you do have to report in Fort Walton Beach beginning today.
Can you do that when you get out today? Can you get down to Fort Walton Beach and report with probation, and then they'll coordinate?
Yeah, it should be.
Who's going to be coordinating and where and all that?
It shouldn't be no problem.
Okay.
Thank you, Your Honor. Your Honor, that completes my business until 1:30 this afternoon, if I may be excused.
See you at 1:30?
Yes, sir. Thank you.
Your Honor, our 130 case, I don't know if Mr. Lowe was transported from Department of Corrections or not.
I just looked into that, and it looks like he was not, but I inquired, my assistant is out. I've asked her to communicate with your Honor's assistant. It may be that Mr. Lowe could be arranged for phone appearance from Florida DOC to make his appearance. I'm confident that he would like the relief requested that's discussed in the paperwork, that's the basis for the hearing. He probably does have a right to be present, at least.
Well, I know, so your Honor's aware the state stipulates to the motion and throughout the sentence.
I hopefully we can get him by phone just to make sure that it's.
Does it require, I've reviewed the
Yes.
issue. I don't have my memo in front of me.
Yes.
But I have reviewed it, and does it require him to be present at a hearing, or can it be?
That was going to be my question, that's why I brought it up, since we're here.
I know that he's 100% on board with it because he had requested the change, so.
I mean, that's what I would look at today, see if it requires I'll look at it too and see if it requires him to be present. In other words, stipulated corrected things represented.
And your Honor,
you enter into an order, and
the state would stipulate the waiver of his presence as well.
Okay.
If that would help.
I mean, it's really, if there's a requirement that he be present, it's his right to be present. So I mean,
given that I had expressly discussed the relief and it's being stipulated to, I don't think it's necessary.
I don't see where the.
And just in practicality, Your Honor, the only thing that transporting him is going to do is make him lose the credit he's gaining.
Right. It's not in his interest.
It's not in his interest.
No, you make a very good point.
The one thing I'm not clear on is because the Second Circuit handles the situation, I'm really here as an appearance because they're the ones that prepared the motion. I need to confer with them on should I do the order or they, because there may be some magic words given that it's an appeal situation. So
why don't you look at as much as you can between now and this afternoon, and we'll try and figure out how to get it resolved. We'll work with you. I mean,
yes,
everybody's in agreement. It's a corrected sentence. It's not even a significant change. So,
yes,
sure. We'll get it done. We'll try and do it as easy as possible. And like you made the point that it's in his best interest not to come over here too.
And Your Honor, Ms. Basso, I think, has something she was
Well,
covering.
Ms. Basso, there's one more case on.
It was covering Mr. Rogers, and I don't see Mr. Tony here. I think that's the issue.
Your Honor, we have apparently Mr. Rogers has Shay Patrick Jones, case number 22-248, set for trial with Mr. Tony. Mr. Tony did announce ready for trial, but we have not seen him, nor have we heard from him.
No.
Your Honor,
I'll be calling his office to check back with me and see if we need to bring him back this afternoon. We'll be calling Mr. Is state ready to go? I mean,
Your Honor,
I know he announced ready to go, but I didn't know if there were any other communications, kind of where.
There haven't been any, Your Honor, but Ms. Sandler did, she was originally going to cover, she left me notes that indicate that yes, the state is ready to go. We're requesting Wednesday, Thursday, or Friday, and a jury, just a standard jury 31 hour.
How long of?
Your Honor, they indicate one day pick and go.
Okay. How many jurors?
30 for the Denari, Your Honor.
And you're looking at just a 1 day?
Yes, sir.
Okay.
And I can leave these notes in the sharp list if that's acceptable.
Sure,
So I'll just
that's
have
fine.
you here anyway.
Yeah, I'm gonna call Mr. Tony, and maybe I'll have my judicial assistant communicate with you and figure out kind of what's going on. Anyway.
So, Your Honor, Wednesday, Thursday, Friday?
Yeah.
I'm just.
That would be the request of the state.
It's not set, it's done. I just wanted to give you.
No, it'll be Wednesday or Thursday because we.
Pick it up.
Yes. We will have, on Friday afternoon, we have the 5-day trial, the homicide trial the following week. We have the pre-trial on Friday afternoon because lawyers were coming in from out of town. So we accommodated them Friday afternoon. So we're not going to do it Friday. So we'll do it Wednesday or Thursday, and quite frankly, I'm open for both of them. Mr. Tony can even choose which one he wants to go, but if we're ready for trial,
We are.
court's ready. Okay.
Thank you, Judge.
We'll communicate with him. Thank you for not letting me walk out.